It looks like everybody's here, so we're going to go ahead and start. Ms. Godinez, do you know if the Creole interpreter is going to be joining us at some point today?
I didn't know we needed one, Your Honor. And actually, I have one that's appearing at 2 o'clock that might be too late, and there's nobody else available. I can have her be available tomorrow at 1.
Okay. Is she appearing virtually at 2?
She's appearing virtually at 2 for Winter Haven, but I can have her come in here first if you wish.
Would you mind?
No. I'll try to figure out who it is.
It's Fritzmel Petion.
Okay, I will make sure that let her know to come into first appearance first. Okay.
I appreciate it. Thank you so much.
No problem.
Okay, so for everybody else, we're going to go ahead and start. If you could please stand to be sworn in.
Si todos se pueden poner de pie para prestar juramento. De pie.
Raise your right hand for me.
Alcen la mano derecha, por favor.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? If so, say I do.
I do.
Juran y afirman que van a decir la verdad, toda la verdad y nada más que la verdad. Respondan en voz alta.
Sí.
Yes.
All right, you guys can have a seat.
Se pueden sentar.
Okay, this is your first appearance hearing. First appearance hearing has 4 purposes and 4 purposes only. First, I will advise you of the charges that have been filed against you. Second, I will ask if you have an attorney representing you. If you've hired counsel and they are present, they will speak on your behalf. If your attorney is not present, you will have the option of proceeding forward with your hearing today or postponing it until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney to let them know you will have court. No one else will do that for you. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I will ask if you can afford one. If so, we will make note of that and move on. If not, and you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending you filling out an application. You have a right to have your attorney present before and during any questioning. You also have a right to communicate with counsel, family, or friends, and if necessary, you will be provided reasonable means to do so. Third, if there are any challenges to probable cause, I will address those. Finally, I will review your bonds and/or other release conditions with you to determine if any changes are necessary. Be aware, if this court places you on pretrial release today, regardless of whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. So if you are given a no contact order, it is in effect immediately. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located as well as where you are located is being recorded. There's an assistant state attorney present listening to everything that is being said, so do not say anything about the crime itself. Please keep these rights in mind as we go through the process. For those of you appearing virtually, if you are a non-lawyer, you are to keep your device on mute during the entire time you are present. In addition, you are not to turn your video feed on at any time. For the lawyers present, please keep your device muted. However, please do turn on your video feed so the court is aware you are present. For all of those present, pursuant to the rules of judicial administration, this meeting is not to be recorded in any manner or form unless you are the press and you have prior permission from court administration. Ms. Godinez.
Buenas tardes. Esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre el cargo o los cargos que se ha presentado en su contra. Segundo, le preguntaré si cuenta con un abogado que lo represente. Si ya ha contratado un abogado y este se encuentra presente, entonces será el abogado quien hable en su nombre. Si su abogado no está presente, usted tendrá la opción de proceder con su audiencia hoy o posponerla hasta mañana. Si decide posponerla, será su responsabilidad contactar a su abogado para informarle que deberá presentarse a su audiencia. Nadie más hará esto por usted. Si usted desea continuar sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si tiene los medios para contratar uno. De ser así, tomaremos nota de esto y continuaremos. Si no tiene los medios y califica la juez asignaría provisionalmente la oficina del defensor público para que le represente, sujeto a que usted llene una solicitud para estos servicios. Usted tiene derecho que un abogado esté presente antes y durante cualquier interrogatorio. Asimismo, tiene derecho a comunicarse con su abogado, familiares o amigos y, de ser necesario, se le proveerán los medios apropiados para hacerlo. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, revisar su fianza y otras condiciones de su puesta en libertad para determinar si es necesaria cualquier modificación. Tenga presente que si la juez lo pone hoy bajo libertad condicional, ya sea de manera directa o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia estarán en efecto inmediatamente, aunque usted se encuentre aún bajo custodia. Entonces, si se le ordena no tener contacto con determinada persona, esta orden entrará en efecto inmediatamente. Durante todo este proceso, usted tiene el derecho constitucional de permanecer en silencio. Si decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde encuentran ustedes, está siendo grabado. Hay un abogado de la fiscalía presente escuchando todo lo que se dice, así que no diga nada sobre sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento. Para quienes comparecen de manera virtual, si no son abogados, deben mantener su dispositivo en silencio durante todo el tiempo que estén presentes. Además, no deben activar su cámara en ningún momento. Para los abogados presentes, mantengan su dispositivo en silencio. Sin embargo, por favor, activen su cámara para que la juez esté al tanto de su presencia. Para todos los presentes, conforme a las reglas de administración judicial, esta audiencia no podrá ser grabada en ninguna forma, a menos que usted pertenezca a los medios y tenga una autorización previa de la administración del tribunal.
All right, Jimenez Ariel Aguilar Herrera. Sir, you're here on a charge of no valid driver's license.
Señor, ¿está usted aquí por un cargo de no tener una licencia válida de manejo?
Do you have
Sí.
an attorney?
Yes. ¿Ya tiene un abogado?
No,
No.
Do you like one?
no.
¿Quiere uno usted?
Mm, sí, pero el problema es que no me puedo comunicar con mi familia.
Yes, but I have not been able to contact my family.
Are you currently employed?
¿Tiene empleo actualmente?
Sí,
Yes.
How much do you make a week?
¿Y cómo está usted? ¿Cuánto está ganando la semana?
es necesario responder.
Do I have to answer that?
No, you don't want to, but I can't appoint a public defender if you don't answer.
No tiene que contestar, pero si usted no me dice cuánto, no le puedo yo asignar un abogado de oficio.
Ok. Bueno, la semana 600, 700 el promedio.
About an average of 600
Okay,
a week.
I'm going to appoint the public defender to represent you.
Le asignaré un abogado de oficio para que lo represente.
I have
Okay.
previously reviewed the affidavit. I do find probable cause.
Ya después de repasar el affidavit, yo encuentro que hay motivo fundado para el cargo
You have a bond of $500.
y tiene usted una fianza de $500.
Thank you, sir.
Ok.
Gracias, señor.
Roberto Barcelo Peraza.
Roberto Marcelo Peraza.
Sir, you're here on a charge of driving under the influence.
Señor, está usted aquí por un cargo de estar conduciendo bajo los efectos.
You have an attorney?
¿Ya tiene usted un abogado?
No, no lo tengo, pero sí me hace falta uno y
I don't have one, but I do need one.
Are you going to hire one or do you need the public defender?
¿Usted contratará un abogado o usted quiere que le asigne un defensor público?
me puede asignar un defensor público o yo puedo contratarlo, no sé.
I would like to have a public defender appointed because I cannot afford one.
Are you currently employed?
¿Tiene empleo usted actualmente?
Sí, yo soy dueño de mi propio camión, de mi negocio.
Yes, I do have my own business. I have my own truck.
But how much do you make a week?
¿Cuánto está ganando usted a la semana?
Es relativo, a veces más, a veces menos.
It just depends, sometimes more, sometimes less.
And you're going to have to fill out
Yeah.
the application and determine if you qualify or not.
Para determinar, usted va a tener que llenar la solicitud.
I have previously reviewed the affidavit. I do find probable cause.
Ya he repasado el affidavit y encuentro que hay motivo fundado.
You have a bond of $1,000.
Y tiene usted una fianza de $1,000.
If you're able
Okay.
to bond out, you will be placed on pretrial release.
Y que, si usted, que al pagar la fianza, usted también será puesto bajo condiciones de libertad condicional.
You must report the day of or morning after your release and report every Monday.
Tendrá usted que reportarse el día después de su liberación y luego reportarse cada lunes.
In addition to the standard conditions of pretrial release,
Que además de las condiciones normales de libertad condicional,
you're not to possess or consume alcohol or enter any bars or lounges.
tendrá usted prohibido poseer o consumir alcohol o entrar a bares o salones.
And you will be subject to random urinalysis and breath tests.
Será sujeto usted a análisis de orina al azar y a pruebas de alcoholemia al azar.
Thank you, sir.
I have
Gracias,
a question.
señor. I have a question.
Es que a mí no se me encontró alcohol y
They
estoy
did not find alcohol.
esperando la prueba de orina porque es que yo no consumí alcohol ni consumí.
I did not drink alcohol. I'm waiting for the tox results.
Okay, that's not a question, but thank you.
No es una pregunta, pero gracias.
Okay.
Rubisny Leva Rodriguez,
Leiva Rodríguez,
you're in charge of driving under the influence.
¿está usted aquí por un cargo de conducir bajo los efectos?
Do you have an
Sí.
attorney?
¿Tiene ya un abogado?
No.
No.
Would you like one?
¿Quiere uno?
Podría ser.
It could be.
It's a yes or no question.
Es una pregunta que es sí o no.
Sí.
Yes.
You currently employed?
¿Tiene empleo actualmente?
¿Cómo si tengo prueba actualmente?
What do you mean?
Do you have a job?
¿Tiene trabajo?
Sí.
Yes.
How much do you make a week?
¿Cuánto está ganando usted a la semana?
1,300.
1,300.
Do you have any dependents?
¿Tiene dependes?
No.
No.
You're not going to qualify for the public defender.
Usted no calificará para un abogado de oficio.
I have previously reviewed the affidavit. I do find probable cause.
Ya repasé previamente la affidavit y encuentro que hay motivo fundado.
You have a bond of $1,000.
Tendrá usted una fianza de $1,000
You are able to bond out. You will be placed on pretrial release.
y que si puede pagar la fianza también será puesto bajo condiciones de libertad condicional.
You must report the day of or morning after your release and report every Monday.
Además tendrá que reportarse el día o la mañana después de su liberación y luego a partir de entonces cada lunes.
In addition to the standard conditions of pretrial release,
Además de las condiciones normales de libertad condicional,
you're not to possess or consume alcohol or enter any bars or lounges.
tendrá usted prohibido poseer, consumir alcohol o entrar a cualquier bar o salón.
And you will be subject to random breath tests.
Y será sujeto a pruebas de drogas al azar.
Thank you, sir.
Gracias, señor.
¿Cuándo puedo pagar la fianza?
¿Cómo?
¿Cuándo podría pagar la fianza?
When can I pay the bond?
That's up to you, sir. Stop leaning on the podium.
Eso depende de usted. Deje de apoyarse en el podio.
Ok.
Elder Martin Ramirez. Elder Martin Ramirez.
Elder Martínez Ramírez.
Sir, you're here on a charge of no valid driver's license and driving under the influence.
Señor, está usted aquí por un cargo de no tener licencia válida de manejar y conducir bajo los efectos.
Do you have an attorney?
¿Ya tiene usted un abogado?
No.
No.
Would you like one?
¿Quiere uno?
Sí.
Yes.
And are you currently employed?
¿Tiene usted un empleo actualmente?
Sí.
I do.
About how much do you make a week?
¿Cómo cuánto está ganando a la semana?
600.
¿Cuánto?
600.
600.
I'm going to appoint the public defender to represent you.
Le voy a asignar un abogado de oficio para que lo represente.
I have previously reviewed the affidavit. I do find probable cause.
Ya he repasado la affidavit anteriormente y encuentro que hay motivo fundado para el cargo.
You have a bond of 500 on the no valid, 1,000 on the DUI.
Y tiene usted un cargo una fianza de 500 en el cargo de no tener licencia y $1,000 por el cargo de conducir bajo los efectos.
If you are able to bond out, you will be placed on pretrial release.
Que si usted puede pagar esas fianzas, usted también tendrá condiciones de libertad condicional.
You must report the day of or morning after your release and report every Monday.
Usted deberá presentarse o reportarse al día o la mañana después de su liberación y luego reportarse cada lunes.
In addition to the standard conditions of pretrial release,
Además de las condiciones normales de libertad condicional,
you are not to possess or consume alcohol or enter any bars or lounges,
tendrá usted prohibido poseer o consumir alcohol o entrar a bares o salones.
and you will be subject to random breath test.
Y será sujeto a pruebas de drogas al azar.
All right, thank you, sir.
Gracias, señor.
Niuska Martinez Beltran. You're here on a charge of resisting officer without violence.
¿Está usted aquí por un cargo de resistirse a las autoridades sin violencia
And interfere with first responder on duty.
y de entrometerse con un socorrista?
Do you have an attorney?
¿Ya tiene un abogado?
No,
No.
Do you like one?
¿Quiere uno?
sí,
Yes.
And are you currently employed?
¿Tiene usted un trabajo ahora mismo?
sí,
Yes.
How much are you making a week?
¿Y cuánto está ganando usted a la semana?
700,
700.
Do you have any dependents?
¿Tiene dependes?
sí,
Yes.
How many?
¿Cuántos?
1,
One.
I'm going to appoint the public defender to represent you.
Yo le asignaré la oficina del abogado de oficio para que la represente.
I have previously reviewed the affidavit. I do find probable cause.
Ya repasé la affidavit anteriormente y encuentro que hay motivo fundado para los cargos.
You have a bond of 1,000 per count.
Y tendrá usted una fianza de $1,000 por cargo.
Thank you, ma'am.
Gracias, señora.
ok,
Ok.
Miguel Melo Roa.
Miguel Melo Roa.
Your Honor, Sandra Smith, Public Defender's Office. My understanding is the alleged victim wants to have contact with him.
Tengo entendido, señoría, que la presunta víctima quiere tener contacto con él.
Sir, you're here on a charge of domestic violence battery.
Señor, ¿está usted aquí por un cargo de violencia intrafamiliar?
Do you have an attorney?
¿Ya tiene usted un abogado?
No.
No.
Would you like one?
¿Quiere uno?
Sí,
Yes.
And are you currently employed?
¿Tiene usted trabajo actualmente?
sí.
Yes.
How much are you making a week?
¿Cuánto está ganando usted a la semana?
Bueno, yo recibo un cheque corto en una semana y otro largo. Uno es de 600 y el otro es de 900. 20
Okay.
más o menos.
I get paid 1 week, I get paid 600, and then the following week I get paid 900.
Do you have any dependents?
¿Tiene usted
No.
dependes? No.
No,
You're not going to qualify for the public defender.
No va a usted a ser elegible para un abogado de oficio.
I have previously reviewed the affidavit. I do find probable cause.
Ya repasé yo el affidavit y encuentro que hay motivo fundado para el cargo.
Based on no prior record and the allegations listed in the affidavit, I'm going to release you straight pretrial release.
Pero basándome en el hecho de que usted no tiene antecedentes penales y las alegaciones que están en el affidavit, yo voy a liberarlo bajo palabra con condiciones de libertad condicional.
You must report the day of or morning after your release and report every Monday.
Usted tendrá que reportarse el día después de su salida o la mañana siguiente después de su salida y luego reportarse cada lunes.
In addition to the standard conditions of pretrial release,
Además de las condiciones normales de libertad condicional,
you're not to use, possess, or carry any firearms, guns, weapons, ammunition, or knives.
usted tendrá prohibido poseer, portar armas de fuego, pistolas, armas, munición o armas blancas.
You may have contact with the victim, but you may not be physically or verbally threatening, violent, or abusive in any manner.
Se le permitirá tener contacto con la víctima, pero usted tendrá prohibido ser abusivo físicamente, verbalmente o amenazando con violencia o de ninguna forma abusiva.
All right, thank you, sir.
Gracias, señor.
Gilberto Perez Rodriguez.
Gilberto Pérez Rodríguez.
So you're here on Hillsborough County warrants for grand theft.
Señor, ¿está usted aquí por una orden de aprehensión del condado de Hillsborough por un cargo de hurto mayor?
And unlawful acts while in the capacity of a contractor.
Y también por hacerse pasar ilegalmente como en la capacidad de contratista.
I have previously reviewed the affidavit. I do find probable cause.
Ya he repasado yo el affidavit y encuentro que hay motivo fundado.
You have a bond of $2,000 on the grand theft,
Tiene usted una fianza de 2,000 en el cargo de hurto mayor
$500 on the unlawful act while in the capacity of a contractor,
y en el segundo cargo de actuar como en la capacidad de un contratista son 500.
If you're still in custody on the 10th of August, we're going to bring you back to court to determine if we're going to release you.
Si para el 10 de agosto aún está bajo custodia, vamos a pedir que lo traigan de nuevo a primera comparecencia para determinar si vamos a liberarlo.
All right, thank you, sir.
Gracias, señor.
Waleska Pons,
Gracias.
Waleska Pons.
ma'am, you're here on a charge of possession of cocaine.
Señor, ¿está usted aquí por un cargo de posesión de cocaína?
Sí, señora.
Yes, ma'am.
You have an attorney?
¿Ya tiene
No,
usted
señor.
abogado? No, no, ma'am.
Do you need the interpreter or not?
¿Va a necesitar la intérprete o no?
Sí,
Yes.
estoy nerviosa. Sé un poquito inglés, pero no entiendo mucho.
I understand a little bit of English.
Do you want an attorney?
¿Va a querer un abogado?
Sí,
Yes.
You currently employed?
¿Tiene trabajo actualmente?
no, señora.
No, ma'am.
I'm going to appoint the public defender to represent you.
Entonces yo le voy a asignar la oficina del abogado de oficio para que la represente.
I have previously reviewed the affidavit. I do find probable cause.
Ya repasé previamente la affidavit y encuentro que hay motivo fundado.
You have a bond of $5,000.
Y tiene usted una fianza de $5,000.
All right, thank you, ma'am.
Gracias, señora. Thank you.
Yasmin Rios Nolasco,
Yasmin Ríos Nolas.
you're here on a charge of driving under the influence
Está aquí usted por un cargo de conducir bajo los efectos
and driving under the influence 0.15 or higher.
y de conducir bajo los efectos con una prueba con resultado de alcoholemia de 0.15 o más alto.
Do you have an attorney?
¿Ya tiene usted un abogado?
No.
No.
Would you like one?
¿Quiere uno?
Sí, por favor.
Yes, please.
Are you currently employed?
¿Tiene trabajo actualmente?
Sí.
Yes.
How much are you making a week?
¿Y cuánto está ganando usted por semana?
300.
300.
I'm going to appoint the public defender to represent you.
Le asignaré la oficina del abogado de oficio para que la represente.
I have previously reviewed the affidavit. I do find probable cause.
Ya repasé previamente la affidavit y encuentro que hay motivo fundado.
As to the driving under the influence, you have a bond of $1,000.
Por el cargo de conducir bajo los efectos tiene usted una fianza de $1,000.
Driving under the influence above a 0.15, you have a bond of $1,500.
Y por el cargo de conducir bajo los efectos con un nivel de 0.15 tiene usted una fianza de $1,500.
If you are able to bond out, you will be placed on pretrial release.
Que si usted puede pagar esas fianzas, usted también será puesta bajo condiciones de libertad condicional.
You must report the day of or morning after your release and report every Monday.
Deberá usted reportarse al día siguiente o la mañana siguiente después de su liberación y reportarse a partir de entonces cada lunes.
In addition to the standard conditions of pretrial release,
Que además de las condiciones normales de libertad condicional,
you're not to possess or consume alcohol or enter any bars or lounges,
usted tendrá prohibido poseer o consumir alcohol o entrar a bares o salones
and you will be subject to random breath tests.
y será sujeta a pruebas de alcoholemia al azar.
All right, thank you, ma'am.
Gracias, señor.
All right, Ms. Godinez, can you please do an announcement? That's all I have.
Yes, Your Honor. ¿Alguien más que vaya a necesitar asistencia en español? No response, Your Honor. And we do have Ms. Stewart coming in at about 2 o'clock.
All right, thank you so much.
You're welcome.
All right, bye-bye. Mr. Gomez, what are you here for, sir?
Mr. Rufino Cabrera.
Cabrera?
Yes, Your Honor, an arrest warrant was issued. He did turn himself in yesterday, and the only charge that has no bond is the aggravated battery. Your Honor, I think the state's in a position that they are in agreement that a bond should be imposed in this case. However, I'd like to make some arguments in regards to the amount of bond.
Okay.
Your Honor, in this case, the aggravated battery is based upon his actions as an alleged principal. The deadly weapon that was allegedly used was used by the co-defendant, known as Mikey. And what shows that I don't believe there's that much evidence. In fact, I think there's positive evidence involving that there was a planned organization. It is according to the victims, he went and attacked what he believed to be his ex-girlfriend's new boyfriend and engaged in a misdemeanor battery. Once that started, the other individual got out of the car. They believe it was either a gun or brass knuckles that were utilized against that individual. So at this point, Your Honor, I think with that in consideration, we would request a $5,000 bond. Obviously, the issues of the pretrial release can impose, such as no contact with the victim, stay away from the victims in this case. And the only other thing I would argue is that he can stay away from Azul. I think this is where the alleged victims work. That, Your Honor, is what I would make a request in this case, considering he does really have no prior record.
And a couple questions. Are you representing him for the duration of the case?
The whole case, he's been retained.
And you're not challenging probable cause?
Obviously, as a warrant has been issued, it's very difficult. So.
And Mr. Cabrera, are you aware of the 3 charges that are pending against you right now?
Yes, ma'am.
Okay, all right. State, do you wish to be heard?
Yes, Your Honor. Just regarding the amount, the state is requesting a $15,000 bond on the second-degree felony. I would note that he is currently charged with a second-degree felony, which does not have a presumptive bond according to the Uniform Bond Schedule.
Okay. Before I tell you what the bonds and conditions are, I'm making an announcement to everybody that's there. Please listen up very closely. Many of you are going to be placed on pretrial release. Many of you are going to have the same conditions on pretrial release, so I'm going to go over them with you really quickly. If I tell you that you have condition 16, it means that you are not to possess or carry any firearms, guns, weapons, ammunition, or knives. If I tell you that you have condition 17, that means you are to have no contact with the victim directly or indirectly, in person and writing, by telephone, pager, fax, text, email, social media, through third person contact. You are to stay 500 feet from the vehicle, the victim's home, vehicle, place of employment, and or school at all times. No contact is no contact. If I tell you you have condition 18, that means that you are allowed to go back to the house one time within 48 hours of your release from custody, accompanied by law enforcement, to get your personal belongings. So keep those in mind when you get called forward. Mr. Cabrera, as to you, I have previously reviewed the warrant. I do find probable cause. At this time, you have a bond of $1,000 on each of the battery charges. You will have a bond of $15,000 on the aggravated battery charge. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release, and report every Monday. In addition to the standard conditions of pretrial release, you're going to have conditions 16 and 17. You're also going to have a curfew from 8 p.m. to 6 a.m., and you're to have no contact directly or indirectly with any of the co-defendants.
And the curfew can be modified for work purposes.
Is he currently employed?
Yes, sure, he is.
It can be modified for work purposes, but he'll have to provide an itinerary of what
Correct.
those work hours
Correct.
are scheduled.
Yes.
Okay, yes. And that means that if it gets modified, that means that's to go to work and to go home, not to go riding around or stop by and get some fast food or go shopping. It is simply to go there and get home. Understand?
Yes, ma'am.
Okay. All right, thank you.
And can I make a statement to my attorney?
No, not right now.
Okay.
Okay. I'll do a virtual visit. Don't speak there because they record everything.
All right, thank you. All right, do I have any other attorneys online?
Yes, Your Honor. Can you hear me?
I can.
This is Kenneth Thomas. I'm here for Mr. Frederick Rose.
All right, Frederick Rose. And, sir, are you representing him for the duration of the case or for today only?
I'll be with him for the duration of the case, Your Honor.
Okay. And have you had an opportunity to review the affidavits?
No, Your Honor, I haven't.
Okay. All right, so Mr. Rose, you're here on a charge of fleeing to elude with lights and siren active, resisting officer with violence, leaving the scene of a crash involving property damage, resisting officer without violence, operating a vehicle and exceeds speed limit of 50 miles per hour plus, culpable negligence, exposure to harm, reckless driving, and add-on charges of resisting officer without violence and trespass on property with intent to commit an offense. So that's what you're being charged with. I have previously reviewed the affidavit. State, as to the resisting officer with violence, I don't find probable cause in what I have. All I have is a conclusory statement that says, and he resisted with violence, but it doesn't tell me how he resisted with violence. Anything?
Can I speak?
Your attorney probably doesn't want you to.
No, he does not want to speak, Your Honor. We had that discussion with him before.
Okay.
Your Honor, at this time, I have no additional information to provide the court as to that count. So based on that, I would be requesting 24 hours.
Okay, so I do not find probable cause on the charge of resisting officer with violence. The state has asked for 24 hours. I will give them the 24 hours. So for that count alone, we'll bring you back tomorrow to determine if they can provide that probable cause. As to the remainder of the charges, I have found probable cause. It's Mr. Thomas, right?
Yes, Your Honor.
Do you wish to be heard regarding bonds?
Yes, Your Honor. I've had an opportunity to look at the administrative orders on the schedule for the bonds, and I think $2,500. Let me see. It's two of them that doesn't have bonds right now, right? That's on charge number 8, which is resisting officer without violence.
There's 2 add-on charges that don't have a bond, and then the resisting officer with violence does not have a bond.
And then they also have no bond on the trespass of property. I don't know what the trespass of property with intent to commit offense mean, but I guess you've had the chance to look at the arrest affidavit. But I think that those are these are misdemeanors, so the bond should be at what, $250?
No, that's not the presumptive bond.
Okay. What is the court looking to? Is it $500?
Well, the presumptive bond's $1,000 on both of those.
Okay. Well, right now his parents are gonna have to come up with the money. He's 19 years old. He's still living with his parents, but they may be able to make the $1,000.
I haven't set bond yet. I was just telling you what the presumptive bond is.
Yeah, Judge, I'm just trying to get him this a bond set so his parents can go ahead and bond him out.
Okay. All right. Your bonds are going to be as follows. As to the flee to elude with lights and sirens, you're going to have a bond of $15,000. As to the leaving the scene of a crash involving property damage, $1,000. Resisting officer without violence, $1,000. Operating in excess of 50 plus miles per hour, $1,000. Culpable negligence, $1,000. Reckless driving, $5,000. Resisting officer without violence, $1,000. Trespass on property, $1,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release, and you report every Monday. In addition to the standard conditions of pretrial release, you are to have no contact directly or indirectly with any of the co-defendants in this case.
Yes, ma'am.
All right.
Judge, may I be heard on the fleeing and eluding? I didn't realize the court was going to raise the bond. My understanding was the bond was previously set at $5,000.
That is the presumptive bond, but if you would like me to enlighten you with the affidavit and exactly what Mr. Rose did to.
I understand, Judge. I understand, and I know he has some anxiety issues, and we're going to deal with that.
Okay. Anything further?
If that's where the court wants to leave it at that.
These
Knowing who he
gentlemen,
is.
these gentlemen put the citizens of this county in great danger with their behavior. In excess of
understand, Your Honor.
140 miles an hour.
I understand, Your Honor. Also, Your Honor, for the record, he, as I stated, he lives in Orange County. I don't know whether or not we'll be able to convince, to do the supervision over in Orange County as opposed to have to every week to show up here in Polk County.
No, he'd have to check in over here in Polk County.
Does he have to phone in or do he have to physically come into the office every week?
Well, when he reports into pretrial release, they'll let him know what he needs to do.
Thank you.
All right, thank you.
Thank you, Your Honor. May be excused.
You may, thank you. We're leaving it no bond, but we're, yeah, I'm gonna bring it back tomorrow for that. Any other private attorneys on the line? All right, Christopher Benny.
Your Honor, Sanderson, Public Defender's Office, I do have a couple follow-up challenges.
I'm sure you do. All right, Mr. Benny, you are here on 2 counts of follow, harass, or cyberstalk, 2 counts of assault on law enforcement officer, and 2 counts of resisting officer without violence. Do you have an attorney, sir?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
Yes, ma'am.
How much are you making a week?
600.
I'm going to appoint the public defender to represent you. Ms. Smith?
I guess I'll start with the 2 assault on law enforcement officers. It's alleged that he was, I believe, in the police car, and it's one second. It's the last paragraph of the affidavit where he's in the police car, and then he just says to the officers, "I'm going to kill you." And then when he gets out, they're going to find you and kill you. Some brotherhood. So bottom line is, and it says, threaten him to do violence. There's no overt act in furtherance of the threat. He didn't get out of the car, or there was no movement after that. And words alone is not enough for an assault charge in any event. Also have a challenge on one of the resisting without violence to officers. It's one ongoing incident. I would say it's resisting multiple officers. Those are my probable cause challenges.
All right, state.
Your Honor, based on the facts of the case, the state would not be contesting no probable cause as to the second count of resisting officer without violence. However, as to the 2 counts of the assault on law enforcement, the state would be requesting 24 hours to allow law enforcement the opportunity to amend their affidavit if the facts of the case support that charge.
Okay, so I have previously reviewed the affidavit. At this time, I find no probable cause for 1 count of resisting officer without violence and no probable cause for both of the assault on law enforcement officers. As to the assault charges, the state's asking for 24 hours to perfect probable cause, which they are entitled to, and I will give them. I do find probable cause on the remaining charges. For each of the follow, harass, or cyberstalk, you have a bond of $1,000 per count. On the 1 count of resisting officer without violence, you have a bond of $1,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16 and 17. We'll bring you back tomorrow to determine if the state can provide that probable cause on those other charges. If they cannot, you will be ROR'd, released on your own recognizance. All right.
And just for clarification, he was ROR today on one of the 2 resisting.
Yes.
And then is he for some reason he's being held no bond on the 2 assault on law enforcement officers, which are first-degree misdemeanors?
We'll put a presumptive bond of 500 on each of those.
500 each of it.
I believe they're
in
both
case he
N2s.
wanted to bond out.
Yeah.
And I apologize, I jumped in, I don't know if we did the public defender, whether we did that or not.
Yes.
We did?
Yeah.
Was that, were we appointed?
You were.
Thank you.
All right, thank you, sir. I'm being presumptive. All right, Wheeler Kennedy.
Yes, ma'am.
Sir, you're here on a charge of driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $500. I also see that you're currently out on bond in CF 265820. At this time, I'm revoking that bond and holding you no bond, Parker v. State. All right, thank you, sir. Raymundo Cantu. Sir, you're here on a charge of trespass on property other than a structure or conveyance. Do you have an attorney?
No, miss.
Would you like one?
Yes, miss.
And are you currently employed? Do you have a job?
No, miss.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000. Thank you. Keith Hansen? Mr. Hansen,
Yes,
you're here
ma'am.
on a charge of possession of cocaine and possession of paraphernalia. Do you have an attorney, sir?
No, ma'am.
Would you like one?
Yes, ma'am.
Are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000 on the paraphernalia, $5,000 on the cocaine, sir. Thank you. Rosemary Tremaine Mays.
Romari Tremaine Mays.
That's the public defender's office. He was here yesterday. I'm gonna email Mr. Henry earlier about before court. There was a different affidavit for one of the resistings involving the Florida Highway Patrol yesterday. So the agreement on this extra resisting is just another agency's involved. The state had agreed to no probable cause, and he'd be ROR on this extra resisting without violence charge because it came out of the same incident. Officers from Florida Highway Patrol and from a different agency were involved on this case. But he got a $1,000 bond on his resisting charge yesterday.
Okay.
Your Honor, that is correct. I have reviewed both affidavits from the two agencies. It does look to be the same exact incident. However, two different law enforcement agencies charged the same count.
Okay. So, sir, you're here on two add-on charges. One is trespass on property intent to commit an offense, and the other is resisting officer without violence. Did you get the public defender yesterday when you were here?
No, ma'am.
Okay. Are you hiring an attorney?
No, ma'am. I also don't live here.
Okay. Well, that really doesn't have anything to do with anything. Do you want an attorney?
Yes, ma'am.
And are you currently employed?
No, ma'am.
I'm going to go ahead and appoint the public defender to represent you. I have previously reviewed the affidavit. I will agree with state and defense, no probable cause on resisting officer without violence. You'll be ROR'd on that. I do find probable cause on the trespass charge, and you have a bond of $1,000 on that. All right, thank you, sir.
So, I got a question, Your Honor.
Yep.
So, both bonds is 100?
No, you have a $1,000 bond on the trespass and your ROR on the other.
And you had the $1,000 bond from yesterday.
All right, Jordan Morris. All right, sir, you're here on a charge of domestic violence battery and violation of probation for your prior charges of criminal mischief, burglary of a structure, burglary, possession of burglary tools, and grand theft. Do you have an attorney, sir?
No, ma'am.
Would you like one?
Yes, ma'am.
Are you currently employed?
Yes.
About how much are you making a week?
About 300.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. As to the domestic violence battery, you have a bond of $5,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16, 17, and 18. As to the violation of probation charges, at this time, you're being held no bond, sir. All right, thank you. We have Calvin Nellums. I hear he was combative. Is that correct?
Yes.
He refused, Your Honor.
Sanderson's public defender's office, this is either the third or fourth time in a row he's been in court. I would just ask to be appointed as it's an in-jail incident. We already represent him on the other case.
All right, any objection to continuing today?
No, Your Honor.
Okay, so Mr. Nellums is, certainly has the right to be present. He has chosen multiple times not to be present. So at this time, we are proceeding in his absence. He is here on charges of resisting officer without violence, assault on law enforcement officer, and resisting officer with violence. I have previously reviewed the affidavit. I do find probable cause. I'm going to appoint the public defender to represent him. He has a bond of $1,000 on the resisting without, $1,000 on the assault, and $5,000 on the resisting with violence. Okay. We have Jerry Seymour.
Yes, ma'am.
All right, sir, you were here on failure to appear cases issued by the Honorable Judge Rayful for possession of paraphernalia, possession of methamphetamine, possession of paraphernalia, possession of methamphetamine, resisting officer with violence, possession of methamphetamine, possession of paraphernalia, and driving while license suspended or revoked. Do you have an attorney, sir?
No, ma'am, I know, I was supposed to go to court tomorrow on the 4th to have all those charges, the time served on them.
Okay,
I believe he might have Iris cerebrin unless he would.
Yeah, I read that, my attorney.
okay, is that your attorney right now?
Yes, ma'am.
Do you want to proceed without him present, or do you want to continue this case to tomorrow and you try to get in touch with him?
I guess, I don't know.
Well, it's up to you, sir.
I guess tomorrow, but I mean,
Okay, we'll
ma'am,
bring you back tomorrow, Mr. Seymour.
ma'am, please, wait.
Sir,
Ma'am?
this isn't a conversation. You
I
either go
need to go
today
to-
or you go tomorrow.
I need to go to the hospital.
Okay, well, that's between you and the jail, sir. I don't make that decision. I'm not a medical personnel. They have medical staff there.
Yes, ma'am.
Thank you. Jeffrey Singleton?
Yes, ma'am.
Sir, you're here on a charge of domestic violence, aggravated battery, and violation of probation for your prior charges of burglary, criminal mischief, and domestic violence assault. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. On the domestic violence aggravated battery, you have a bond of $15,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16, 17, and 18. As to your violation of probation charges, at this time, you are being held no bond, sir.
Yes, ma'am. Thank you.
Danny Taylor?
Yes, ma'am.
Sir, you're here on a charge of aggravated battery. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Are you currently employed?
Yes, ma'am.
About how much are you making a week?
About 6.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $15,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16 and 17, sir. All right,
Thank you, ma'am.
That's all we
Is
have
that
in
it?
South County, Your Honor.
All right, have a good day.
You too.
All right, we have Crystal Collins.
Oh, okay. Miss Andrews, sit down.
Ms. Collins, you're here on a charge of possession of cocaine and violation of probation for resisting officer without violence, introduction of contraband into detention facility, and possession of paraphernalia. Do you have an attorney, ma'am?
No, ma'am.
Do you like one?
Yeah.
And are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on the possession of cocaine, and you're being held no bond on the violation of probation, ma'am. All right, thank you. Who was the other one that you had up first?
That was Andrew Johnson, Latasha.
Oh, they told me she was a takeoff, but she's here, so come on up.
Oh, yeah, Andrews, William take off.
I have Latasha Andrew Johnson. Okay, ma'am, you're here on a charge of petty theft. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
Yes, ma'am.
How much are you making a week?
500.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $500, ma'am. Thank you. Madison Graham?
Yes, Your Honor.
Ma'am, you're here on a charge of resisting officer without violence. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, Your Honor.
And are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000. I also see that you're out on pretrial release and bond in CF 26-6871. At this time, I'm revoking that and holding you no bond, Parker v. State. All right, thank you.
Yes, Your Honor.
All right, I have Ms. Stewart on the line.
Yes, Your Honor.
All right, Ms. Stewart, we have one Creel case, and that is Fritznell Petian.
Christelle Petion?
Yes.
Sir, you're here on a charge of driving under the influence above a .15.
Monsieur, ou là, ou t'as conduit en bas influence qui était plus haut de 1,5.
Do you have an attorney, sir?
Est-ce qu'on a un avocat, monsieur?
Non, pas un avocat.
No, I don't have an attorney.
Okay, would you like one?
Est-ce que t'as aimé une?
Oui.
Yes.
And are you currently employed?
Est-ce que vous travaillez qu'on y a?
Yeah, ma travail, oui. Je suis supposé aller travailler aujourd'hui, ah bon.
Yes, I'm working. I was supposed to go to work today. Well,
Okay, about how much do you make a week?
OK, combien vous touchez par semaine?
Je touche $700 par semaine.
I get paid $700 per week.
Do you have any dependents?
Gen moun qui dépend de vous?
Non.
No.
You're not going to qualify for the public defender, so you'll have to hire an attorney.
Ou pas qualifié pour avocat public là, donc ou a besoin pour employer propre avocat.
I have previously reviewed the affidavit. I do find probable cause.
M'te révisé affidavit là et m'te joint une cause probable.
You have a bond of $1,500.
Ou gen une bonne caution de $1,500.
If you are able to bond out, you will be placed on pretrial release.
Si que ou capable payer pour bon nan pour sortir, yo pral mettre yo sous programme relâchement avant jugement.
You must report the day of or morning after your release and report every Monday.
Faut qu'on rapporter jour nan après ou fin yo la guerre là et chaque matin après ça.
In addition, I'm sorry, in addition
Sorry,
to
Your
the
Honor.
standard conditions of pretrial release,
Et chaque lundi après ça, et conditions qui en additionné de relâchement avant jugement,
you are not to possess or consume alcohol or enter any bars or lounges.
ou pas de posséder ni boire aucun alcool, entrer dans aucun bar ou bien place comme ça.
And you will be subject to random breath tests.
Et vous prenez un bas sujet pour vous prendre test bouche n'importe là.
All right, thank you, sir.
OK, merci, monsieur.
Okay.
All
OK,
right, thank you very much, Ms. Stewart.
thank you, Your Honor. Have a great evening.
You too. Johanna Howard,
Yes, ma'am.
ma'am, you're here on a charge of domestic violence, aggravated assault with a deadly weapon without intent to kill, and domestic violence felony battery. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
No, ma'am, I'm on disability.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 per count. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16, 17, and 18, ma'am. Thank you. Brenda Rasnick.
Yes.
All right, ma'am, you're here on a charge of possession of methamphetamine, possession of paraphernalia, and keeping a shop or vehicle for drug use. Do you have an
Yes.
attorney?
No.
Would you like one?
Yes, ma'am.
And are you currently employed?
No.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,000 on keeping a shop or vehicle for drug use, $1,000 on paraphernalia, and $5,000 on possession of methamphetamine, ma'am. All right, thank you. Heather Settler?
Yes, ma'am.
Ma'am, you're here on a charge of driving under the influence, refusal to submit to a breath alcohol test, and battery on law enforcement officer. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Are you currently employed?
I was up until today.
All right, about how much were you making a week?
500.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. As to the driving under the influence, you have a bond of $2,000, refusal to submit $1,000, battery on law enforcement $5,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you are not to possess or consume alcohol or enter any bars or lounges, and you will be subject to random breath tests.
Yes, ma'am.
Jessica Vlasic?
Yes, ma'am.
All right, ma'am, you're here on a charge of battery on law enforcement officer, resisting officer without violence, and resisting officer with violence. Do you have an attorney?
No, ma'am.
Do you like one?
Yes.
And are you currently employed?
I'm on unpaid maternity leave.
Okay, so you have no income right now.
Correct.
Okay, I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000 on battery on law enforcement officer, $1,000 on resisting officer without violence, and $5,000 on resisting officer with violence.
Yeah.
Thank you.
Thank you.
Is that all of the females?
That's all the females that are here, Your Honor.
Okay, do I have William Andrews?
Who was it?
That was the takeoff.
He was the takeoff.
Unable to appear due to medical.
I would ask to reset tomorrow.
Okay, we'll bring him back. I must have mixed those two up. All right, so this must be Devontae Black.
Sanders Smith, Public Defender's Office. I do have a stipulation with the state. He's charged with 4 counts of resisting officers without violence. The stipulation that is on 3 of the 4 counts that there is no probable cause and that he should be released on his own recognizance.
All right, state, you're in agreement?
Yes, Your Honor.
All right, so sir, you're here on a charge of unarmed burglary of an unoccupied dwelling, 4 counts of resisting officer without violence, violation of probation for your prior charges of burglary, criminal mischief, possession of ketamine, and possession of methamphetamine, and then a warrantless violation of probation for those same 4 charges. So there's a warrant out there, and then they arrested you on a warrantless violation of probation, and then you have your new charges. Do you have an attorney, sir?
No.
Would you like one?
Yes.
And are you currently employed?
No.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I am in agreement with state and defense. As to 3 counts of resisting officer without violence, I do not find probable cause, and you will be ROR'd. As to the remaining charges, I do find probable cause. Unarmed burglary of an unoccupied dwelling, you have a bond of $15,000. 1 count of resisting officer without violence, you have a bond of $1,000. And on the violation of probation charges, you are being held no bond, sir. All right, thank you. Blake Carper.
Good afternoon, Your Honor.
Afternoon. Sir, you're here on a charge of domestic violence battery. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
Yes, ma'am.
How much are you making a week?
400 to 500.
Polk County Sheriff.
I get paid every 2 weeks. So.
All right, give me just a second. I don't know what that was, but I just want to make sure everybody's muted because that was odd. Okay, it does look like everyone's muted. All right, sir, I'm going to go ahead and appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $5,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you're going to have conditions 16, 17, and 18, sir.
Yes, ma'am.
All right, thank you.
I know.
Darrell Green. Sir, you're here on a charge of first-degree arson. Do you have an attorney?
Well,
Would you like one?
yeah.
And are you currently employed?
Oh, well.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. State, you wish to be heard?
Yes, Your Honor. At this time, the state intends to file a motion for pretrial detention, permission to approach.
Granted.
Thank you, Your Honor. If the court finds that that motion is legally sufficient, we are asking the defendant to be held no bond on this count. We would ask for him to be set for a pretrial detention hearing next Monday, August 10th at 1 p.m. in the A2 division.
And I have reviewed the motion for pretrial detention. I do find that it is legally and facially sufficient. Having found probable cause at this time, you are going to be held no bond, sir, but you're going to have that hearing next Monday, and that judge is going to determine if they're going to give you a bond or not, okay?
Yes.
Thank you.
Thank you, Your Honor.
Thank you. Comadre Gregory.
Yes, ma'am.
All right, sir, you're here on a Seminole County warrant for a charge of criminal use of personal ID. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $3,000. So if you can bond out, you can do that. If you can't bond out, we're going to notify them that you're ready for pickup. If you're still here on next Monday, the 10th of August, we're going to bring you back to court to determine if we're going to release you.
Yes, ma'am. One genuine question, please.
You can ask. I mean, if this
I
charge,
know
I have no jurisdiction over it, so there's nothing I can do.
I know it's just I literally I'm so lost about the charge. I just wanted to ask, like, what if I'm dealing with identity theft or something? Cause I'm lost about the charge in general.
Well, that's what I said, sir. This is Seminole County. I
Okay.
have no jurisdiction.
Yes,
I
ma'am.
didn't issue the warrant. I have no idea what this is about.
Yes, ma'am. Me either, but I appreciate it. Yes, ma'am.
Thank you. Daniel Guzman,
Yes, ma'am.
sir, you're here on a charge of driving under the influence. Do you have an attorney?
Yes.
Who's your attorney?
Trinidad Peraza.
Okay, do you want to proceed today without them, or do you want to be brought back tomorrow and have them present?
What changes?
Whether your attorney's present or not.
I'll proceed without them.
Okay. I have previously reviewed the affidavit. I do find that there is probable cause. You have a bond of $1,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you are not to possess or consume alcohol or enter any bars or lounges, and you will be subject to random breath tests.
All right, thank you.
Richard Harding. All right, sir, you're here on a charge of culpable negligence, exposure to harm, improper exhibition of a firearm or dangerous weapon, domestic violence, aggravated assault with a deadly weapon, domestic violence, battery by strangulation, domestic violence, false imprisonment of a person, and discharge of firearm in public or residential property. Do you have an attorney, sir?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. State.
Your Honor, at this time, the state intends to file a motion for pretrial detention as to the 3 counts of domestic violence. Permission to approach.
Granted.
Thank you, Your Honor. If the court finds that that motion is legally sufficient, we are asking for the defendant to be held no bond as to those 3 counts and for him to be set for a hearing, a pretrial detention hearing next Monday, August 10th at 1 p.m. in the A2 division.
I have reviewed the motion for pretrial detention. I do find that it is facially and legally sufficient. At this time, as to the charge of culpable negligence, you have a bond of $500, improper exhibition of a firearm, $1,000, discharging firearm in public, $1,000. As to the domestic violence aggravated assault, domestic violence battery by strangulation, and domestic violence false imprisonment, you are going to be held no bond on those 3 counts, with a hearing to be held next Monday on the 10th for that judge to determine if she or he will give you a bond. All right, thank you.
Thank you, Your Honor.
Brian Hodolitz.
Yes, ma'am.
All right, sir, you're here on a charge, Pinellas County warrant for violation of probation on your prior charge of driving under the influence. Do you
Correct.
have an attorney? Oops, I'm sorry.
My wife was working on one.
Okay. I have previously reviewed the affidavit. I do find probable cause. At this time, you are being held no bond. They also have another thing. It's called a hold for Pinellas. It's the same thing. There's a hold for Pinellas because of the violation probation warrant that's out there. So you're being held no bond on those. We're going to notify Pinellas that you're ready to be picked up. If you're still here next Monday on the 10th, we're going to bring you back to court so we can determine if we're going to release you or what we're going to do, okay?
Yes, ma'am.
Thank you, sir. Tajamar Hyatt.
Good evening, Your Honor.
He was here yesterday, Judge Horton. I had, I believe, a challenge. He didn't have the warrant on him yesterday for this fugitive case.
Okay.
So he's brought that today to see if they have the warrant. I think I'm just now getting possibly it from the state.
Okay, so sir, you're here on a fugitive from justice from New York.
Yes, Your Honor.
Give me just a second. I'm looking at this.
Yesterday, we didn't have the warrant. We just had the sheriff's office arrest report.
State, do you have something different?
Your Honor, I do have a copy of the warrant today that I can either email the court or provide. I have provided it to Ms. Smith, But if the court doesn't have it, I do have a copy of it pulled up, or I can email it.
I do not have it.
What would be the best email to be able to make that part of the court record?
Kristen, CHRISTEN, Camacho, CAMACHO, hyphen Castillo, CASTILLO, at polk-county.net. I mean, .gov, sorry.
If I may just have one moment, Your Honor, in order to send that.
Sure. Mr. Hyatt, just have a seat real quick. I'm just going to go through a couple more until I get that, okay?
Yes, Your Honor.
Hector Melendez.
Yes, ma'am.
Melendez, you're here on an arrest warrant issued by the Honorable Judge Hill on a charge of career offender failing to register and then a violation of probation on your prior charge of burglary of an unoccupied dwelling. Do you have an attorney, sir?
Yes, ma'am.
Who's your attorney?
Melendez Law Firm from Osceola County.
Okay. Do you want to proceed without them today?
Yes.
Or do you want to be brought back tomorrow?
No, we'll proceed.
Okay. I have previously reviewed the arrest warrant. There is probable cause. As to the career offender, you have a bond of $5,000. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday.
What's wrong with
Actually,
the
every
guy on the
day.
left?
In addition to the standard conditions of pretrial release, you are not to use, possess, or carry any
definitely under
firearms,
the
guns,
influence.
weapons, ammunition, or knives, and you will be placed on a GPS monitoring device. As to the violation of probation, at this time, you are being held no bond, sir.
Yes, ma'am.
All right, thank you. Corey Shalen.
Sanderson, but,
Judge Phelan refused.
I would point out that, I believe, I don't remember, yesterday we had 128, but Judge Wharton wanted to continue this over to see on Mr. Shalen whether or not what his violation was correct or not. Just one second, I have the wrong stuff. There's not a warrant, it's
It's an affidavit.
right. And the violations are something that don't normally go along with these type of charges. And so I did look at all of the conditions in both cases. I personally, unless I missed it, I didn't see that he was ordered not to be able to go on the internet in any fashion. These are not the type of, the charges that you would normally have this type of provision for.
Well, I don't think this says that he wasn't allowed to go on the internet. I think it's that they're unregistered identifiers and that he's supposed to notify what his identifiers are when he's on.
I don't know if is that a condition of the probation? Judge Wharton did not think that.
I don't know, but I'm not in a position to question an officer who signed an affidavit saying that it is at this point.
Well, I guess he's not here. Do we want to continue this, I guess, another day?
Judge, he did come up. He said this was his third day and he would not step up in front of the podium because this was his third day for the same thing.
Okay, well, I find probable cause. He's being held no bond. We'll appoint the PD in an abundance of caution since he's uncooperative. Do you have? Okay. Ty Walker?
Yes, ma'am.
All right, sir, you're here on a charge of driving while license suspended or revoked. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
Are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. At this time, you have a bond of $500, sir.
Yes, ma'am.
Thank you.
Thank you.
Wayne Walter?
Yes, ma'am.
All right, sir, you're here on a charge of battery on person 65 years or older and assault on person 65 years or older. Do you have an attorney?
My wife's working on one.
Okay, if that doesn't work out, just let the judge know your next court date, okay? I have previously reviewed the affidavit. I do find probable cause. At this time, you have a bond of $5,000 per count. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16 and 17, sir.
Thank you.
Thank you. Timothy Williams?
Sanderson, Public Defender's Office. This is a bring back from yesterday. I believe I was the one that had the probable cause challenge of the cocaine yesterday. I believe, I received a new report, at least,
There was an amended affidavit, I believe.
okay, that said that it did test positive for cocaine, so I no longer have that probable cause challenge.
All right, so sir, you're here on a charge of battery and possession of cocaine. Do you have an attorney, sir?
No, ma'am.
Do you like one?
Yes, ma'am.
Okay, and are you currently employed?
No, ma'am.
I'm going to appoint a public defender to represent you. I have previously reviewed the affidavit. I do find probable cause. You have a bond of $1,500 on the battery, $5,000 on the cocaine. If you are able to bond out, you will be placed on pretrial release. You must report the day of or morning after your release and report every Monday. In addition to the standard conditions of pretrial release, you have conditions 16 and 17.
So what you saying on $1,000 and what on one?
On battery, $1,500, and possession of cocaine, $5,000. All right, thank you. Jaden Yorn?
The Sanderson Public Defender's Office, I have a probable cause challenge.
Yes, ma'am.
All right, sir, you're here on a charge of follow, harass, or cyber stalk another. Do you have an attorney?
No, ma'am.
Would you like one?
Yes, ma'am.
And are you currently employed?
No, ma'am.
I'm going to appoint the public defender to represent you. Yes, Ms. Smith?
He's charged with stalking, cyber stalking, under 784.048, so paragraph 2 on the front page of the arrest report. My argument is that this is a one-time incident, that statute does not pertain to the incident alleged in the affidavit. It is a one-time incident, and stalking is more than one time.
State?
Thank you. Your Honor, based on my reading of the affidavit, it does appear that the defendant should have been charged with sexual cyber harassment charged under 784.049, not 784.048. Based on that, Your Honor, the state is requesting 24 hours, as it does appear he was booked in under the incorrect charge.
Okay. I have previously reviewed the affidavit. I do find that there's not probable cause as to what is in the affidavit. State is requesting 24 hours to correct that issue. I am going to allow the 24 hours to correct that issue. You'll be brought back tomorrow to determine if it can do that or not.
Thank you.
Thank you. And Mr. Hyatt, I think we have,
If I may just have one moment, Your Honor, I've been having some technical difficulties.
we're working on you still.
Okay, Your Honor.
30 seconds.
Could I ask a quick question, Your Honor, before, or is that?
You can ask. I don't know if I can answer.
Of course. So yesterday when I was here, I was informed that there was a hearing for the 10th. Was that for Florida or New York? I just wasn't aware, of which.
That should be your fugitive hearing. So once probable cause is determined, then they have a fugitive hearing for basically you and your attorneys to figure out, are you going to be extradited back? What's going to happen with your case?
So that hearing would be here in Florida, correct?
Yes.
Okay, thank you. That's all I wanted to be aware of.
I believe I have sent the affidavit, or I should say the warrant to the correct address. Please let me know if you received it. Sorry for the technical difficulties.
That signature didn't get on this one.
Go ahead and show me your computer.
If that's all right, please, Your Honor, permission to approach.
It might be a little easier.
Sorry, Your Honor.
That's okay.
It should be a copy of the warrant from New York.
And yours is not touchscreen, right?
No, Your Honor.
That's okay.
Should be a one-page.
See. Oh, I got it. Oh, no, now. Now that I have the computer, I'm sorry.
But no, that's on my end with new email.
Okay.
Thank you, Your Honor.
Thank you. I have reviewed the warrant at this time. There is a fugitive from justice out of New York warrant for you.
Yes, ma'am.
Do you have an attorney?
Well, I have an attorney in New York, but for Florida, I will retain one.
Okay, so you're going to retain your own here?
Yes, ma'am.
Okay, so I have reviewed that warrant. There is probable cause at this time. You are being held no bond, and you are still scheduled for that fugitive hearing. That's going to be next Monday,
Yes,
on the
ma'am.
10th, and that'll be at 8:29 in the morning.
Yes, ma'am. Thank you.
All right, thank you. All right, is that everybody?
I just have one reschedule, I'm assuming they bonded, but Centeno, Saraguso, Angel Thomas.
Yeah, I have bonding.
Oh, thank you.
Yeah, I missed that one.
All right, you guys have a good day.
All right.
You
guys,
too,
give me
thank
a
you.
moment so I could switch on over. For those of you guys that want to watch the parole board hearings, I'm gonna switch it on over right now, and we'll go ahead and watch the parole board hearings from earlier. Oh shit! Hold on. Where the hell is it? Oh, okay. Damn! I thought I closed the screen. Okay, let me switch on. I gotta switch it over to a different screen right now. All right. So this is going to be from earlier on. I think it's going to be about like about 2.5 hours or so. Let me just cue it up to the point where it starts up. And Juan, right now, I'm not sure when I'm going to be having a live from anybody from prison. They're making some changes right now with the phone service from they're switching over from GTO over to Securus. So, and then I also need to set up an account. Set up an account so I could go and start communicating with them again. But I've been definitely slacking on the phone calls and whatnot. Just like I mentioned, earlier on, it requires a lot of me, to be here, to make these phone calls and whatnot. So I really haven't had the time to do it. But hopefully in the future I am able to continue, with the phone calls from prison and whatnot. Right now I'm focusing on some other things. For those of you that I'm not aware, I do have a TikTok and Instagram. I've been focusing a lot of my energy on Instagram. So if you want to see about some of the stuff I'm talking about over there, then I'll go ahead and invite you over there to that part of the social media realm, if you will. So let me just get it up to where it starts.
Thank you.
Thank you.
We can disconnect now. Thank you.
All right, there it goes. So let me see how much time this one has left on it. James talking. Oh man, I tried to turn the camera on, but I haven't been on camera for a bit, so I couldn't even. I don't know. I gotta reset the settings. Anyhow, hey, I do appreciate you guys that come on to the channel. Day after day. Week after week, month after month. Appreciate every single one of you guys. All right, I am Collect Call James. With that being said, I'm gonna go ahead and step into the background and do my thing. If you want, Juan, highly appreciate you, man, for sure.
Good morning, Brooklyn. Can you hear me? It looks like you're muted and your camera is off.
So
Perfect.
the inmate that we're trying to get up here, he's refusing to show up to this. We tried to call him. He told us he was.
Yeah, so I have his attorney here. She said she spoke with him Friday. He's refusing to come. Mr. Wong Sa?
Wong Sa, yeah,
Really?
yes.
Continue maybe to the next available date and I can call him between now and then.
Okay, all right, so we're just gonna his attorney is just gonna continue today to try to give him one more chance and try to get in touch with him to bring him back. I think my hearing's next week, so we'll try again. If you talk to him or anybody does, we'll try one more time and she'll
Okay.
reach out to him also, okay?
Perfect.
All right, thank you.
Thank you.
Thank
We're
you.
gonna,
Yeah.
we can disconnect now. I'm just gonna, Kristen, well, you'll stay live. I'm just gonna go on the record,
Yeah.
okay, Attorney Dean?
Absolutely.
So good morning. I'm Parole Officer Trisella. I'm a hearings examiner for the Board of Pardons and Paroles, and this is a revocation hearing concerning Jador Wong San, inmate number 421850. And today is Monday, August 3rd, 2026. Per the facility and correction officer, Mr. Wong San is refusing to come down for his hearing. Council has asked for a continuance to the next available hearing date to see if he will appear. That hearing date is a lot. My next hearing date is the 20th.
Oh, the 20th?
Yeah, I mean, it's best at probably the 13th.
That's okay. I'm fine with if it's.
Okay, all right, so we are gonna continue Mr. Wong San's hearing to August 20th to see if he would like to participate next time, and we'll touch base with council then too. Council, you are okay with this?
Yes, thank you very much.
So this does conclude the matter for Mr. Wong San, inmate number 421-850 for today. Kristen, any reason why Cybulski can't be answering? Or isn't answering?
I see it trying to dial, so my guess is an officer's not right there in the room. I'll give them a call.
Thank you.
Hello?
Hi,
He's on his way down now. He'll be here in a second.
perfect. Thank you so much.
Sorry about that.
Thank you, Kristen.
Hey, can you send 15 Bravo, Frank Vaughn, or one thing? Yeah, probably it starts now. I think it says. Yeah, I got the one. Yep. All right, thank you. Hi, ma'am.
Hi.
Mr. Laurent says he does not want to participate.
Okay, so he's refusing to come down then?
Yeah, he don't want to come down. He said
Okay,
he's good.
thank you. I appreciate it.
Sorry about that.
No problem. Have a great day.
You too.
So I am gonna go on the record quickly. My name is Parole Officer Trisella. I'm the examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning LaRon Frank, inmate number 237401, and today is Monday, August 3rd, 2026. Mr. Frank is refusing to come down for his hearing, so his case will be reviewed administratively and he will be notified of any decisions made. Corrigan, it looks, yeah.
So.
Corrigan, are you able to unmute and turn your camera on?
Good morning.
Good morning.
Are you ready for Ortiz?
Yes, please.
I'm in shortly.
Okay, thank you.
Yeah, the right one. Roll. Yeah.
Good morning, Mr. Ortiz. How are you?
Good.
We're gonna get started, okay?
Okay.
All right, so good morning, I'm Parole Officer Trisell, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Esteban Ortiz, inmate number 247811. Today is Monday, August 3rd, 2026, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Corrigan Correctional Institution. Can you please state your full name and DOC inmate number for the record?
247811.
And your full name, please?
Esteban Ortiz.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means we're releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked, and if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Ortiz, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Thank you. So we're going to go over the procedure for today. So first I'm going to read your rights. Then we'll review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I don't, ma'am.
Okay, so you do have important rights, and we're going to review them now. You have the right to be represented by an attorney. If you cannot afford, you can hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So, Mr. Ortiz, were you told that you can have an attorney here to represent you for today's hearing?
Yes, I was told. Yes.
Do you intend to seek counsel?
No, no.
Okay, so just one more time to confirm, you are willing to move forward today without legal representation?
Yes, yes.
You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
Perfect. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, I do, ma'am.
Okay, we'll now review the charges that the state, your parole officers, bring against you, and the information underlying each charge. So on charge number 1, the condition of absconder, the charging officer reported that on 5/23/26, you walked out of your only parole-approved residence, Central Ave halfway house, without permission or authorization. You failed to return to the halfway house on 5/23/26 or any point thereafter. You made no attempts to contact the halfway house or parole to disclose your location, and your whereabouts in the community remained unknown until 6/4/26, when you turned yourself into your court date on 6/24/26. You were unaccountable in the community for a total of 12 days. Charge number 2, the condition of halfway house placement, the charging officer reported that on 4/30/26, you walked out of your parole-approved residence, Central Ave halfway house. You returned back to the halfway house on 5/1/26, leaving you unaccountable for 20 hours and 14 minutes. On 5/23/26, you walked out of your only parole-approved residence, the Central Ave halfway house, without permission or authorization. You failed to return to the halfway house on 5/23/26 or any point thereafter. Your whereabouts in the community were remained unknown until 6/4/26, when you turned yourself in at your court date on 6/4/26. You're unaccountable in the community for 12 days. Your actions are in violation of your signed halfway house agreement, which states, I will not leave the physical confinements of the halfway house unless authorized by program staff or parole. I will only go to the locations indicated on an approved community pass and will, unless changes have been authorized by staff. The evidence submitted by the state was already reviewed at the preliminary hearing. That all does remain the same. So one more time to confirm, Mr. Ortiz, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today's purposes?
Yes, I did.
And you were able to review all that information?
Yes, ma'am.
Okay, and we don't have any witnesses at this time. Oh, and I also have not received anything from you, Mr. Ortiz. Do you need any time to submit any documents or evidence on your own behalf? No, okay. All right, so at this time, it is your opportunity to respond to the parole violation charges against you. However, remember, you do have the right to remain silent if you choose to do so. So at this time, would you like to testify towards the charges brought against you?
No, ma'am.
Okay. Then I am just going to announce my findings, okay, Mr. Ortiz?
Sure.
Okay. So on charge number 1, I am finding that you violated the condition of absconder based on the evidence presented in state's exhibits D, J, and M. And on charge number 2, I'm also finding that you violated the condition of halfway house placement based on the evidence submitted in state's exhibits D, E, H, I, J, and M. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So any comments now, Mr. Ortiz, about your plans for release, where you want to live once you get out, stuff like that?
Plan just see if I can continue with my what I was doing before I got incarcerated with company of land home improvement and live a criminal-free life with my family.
Okay. So you were working, you said?
Yes, I had I was part owner of a company.
You're part owner of the company?
Yeah,
Okay.
yeah, a construction company. Yes.
Okay. So you'll be able to jump back into that?
Yes, ma'am. That's my goal when I get out of here.
Perfect. If you are released, where do you plan to live?
If once I get released with either my sister or my girlfriend, my wife.
Okay, so I wouldn't have to do a halfway house placement stipulation, then you have a sponsor?
Well, if I do get released, I'm gonna have to go to the halfway. I don't have a sponsor yet.
Okay. So you're saying at your end of sentence, right? Because
Yes,
you're kind of close to it. So once you're done, you'll be living with them? Okay.
Yes.
Okay. So if, once I make my recommendation, we'll get more into that. If you are released back onto parole, what's your halfway house location preference?
Waterbury.
Waterbury, okay.
Yeah.
Anything else, Mr. Ortiz, you'd like the board to know before I do announce my recommendation?
No, ma'am. Just that at first I used to think that this special parole thing was a big it's a scam, but it made me realize a lot of things. Open my eyes to a lot of things. Like this is not the life I want to live for the rest of my life. I don't want to be in and out, and I don't want to be through the court systems. So it's kind of an eye opener.
Yeah, it's not there to hurt you. Ideally, it's there to help you if you use it the right way, right? Or
yes,
look at it the right way.
Even if you don't use it the right way, with the back and forth, you eventually get tired of it. You're like, you know what? I give up.
Yeah, absolutely. All right. So do you just want to note on the record, Mr. Ortiz, this is your 4th violation of special parole?
Yes.
And you do have 2 prior criminal violations and 1 technical, plus you did have a rescission in the past also for your behavior. You were only out in the community for 3.5 months, and you do have a sentence running in the background, correct? You're serving time right now?
Yes, ma'am.
Okay. So with that, I am going to recommend that your parole be revoked and that you receive no new re-parole date, which is an approximate 6-month period of confinement as a sanction, as your special parole ends on December 12th, 2026.
Yes.
I do have noted that the earliest date the board can release you is October 25th, 2026, which is the earliest date on your new conviction. That conviction ends on, that's a 6-month conviction. I think I just said that, didn't I? Or maybe I didn't. That was a 6-month conviction, correct?
Yes, ma'am.
All right, and that one ends on November 20th, 2026. So I'm going to recommend to the board, in case they decide to lessen it, which they can, the following conditions: no consumption of alcoholic beverages, behavioral management program for domestic violence, a general no contact with OL and KG without parole officer's permission, and halfway house placement in Waterbury. So what happens, Mr. Ortiz, is I'm going to send my recommendation to the board on October 13th. On that date, the board can lessen that recommendation if they choose to do so. So they can, the earliest date they can pick is October 25th of 2026. But they can pick any date between then and your December end of special parole date if they choose to do so. And if they do choose to do so, those conditions are going to be the ones that I recommend for it, okay?
If they pick a date before December 12th, that means I have to go be halfway house placement again.
Yeah, like
Correct.
you just said that you'll need it till you're done with special parole for now. So yeah, they would put you in a halfway house. Yeah.
Okay, okay.
And let me correct myself. So October 25th is the earliest date the board can give you.
Yeah, 'cause-
However, it's up to DOC if they would release you before November 20th, okay?
okay.
So we might say, okay, the board might say, let's give them an extra 6 weeks, but then it's still up to DOC to then say, well, we're gonna let him out before his end 6-month sentence, or we're gonna make him stay in until that November 20th date. But then at that date, you'd go out onto special parole until you're done,
Alright.
2 weeks later, December 12th. So there's some possibilities. It's really up to the board's decision on the 13th. And we'll put that in the mail to you that day, so you'll get it about a week later what their final decision was.
Okay, but once December 12th come, that means
Yeah.
I'm
Walk
completely
out the
upset.
door.
Okay,
Yeah.
man. That's
All
what
right.
All right.
Yeah, so worst case scenario, I mean, not ideal, but worst case.
Yeah, it's a good news, and you know, I already got my mindset that I'm December 12th. So
And then you don't have to deal with this, right? Well, as long as you do what you're supposed to do when you're out there, you won't see any of us again, right? But
if I do get an early date, trust me, regardless what day, you won't see me again.
it's the other thing, you still have that chance. If they give you an earlier date, just try your best, right?
All right.
Because
All right,
don't want
man.
to see you before that December date for sure. But
Okay.
hopefully we never see you again, okay, Mr. Ortiz?
All right, man.
All right, good luck to you.
Thank you.
So
Have a
this
good night.
concludes the revocation hearing for Esteban Ortiz, inmate number 247811. All right, take care.
Bye-bye.
Thanks. Ooh, Kristen, what happened? Yeah. Perfect. Good morning, McDougal.
Good morning.
I think I just have one with you today, Mr. Dwyer.
Yeah, he's en route right now.
Okay, perfect. Thank you.
All right, no problem.
Good morning, Mr. Dwyer. How are you?
All right.
Oh man, we're gonna get started. Okay. So good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Deshaun Dwyer, inmate number 393038. And today is Monday, August 3rd, 2026. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and McDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Deshaun Dwyer, 393038.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as each of the charges against you. The state, not you, has a responsibility to prove the allegations by preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you on parole, placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Mr. Dwyer, can you please raise your right hand? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. So we're going to go over the procedure for today. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state or parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
All right, so you do have important rights, and we're going to review them now. The first is you have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So, Mr. Dwyer, were you informed that an attorney could represent you for today's hearing?
No, I thought they was gonna dispose of all the charges. Then like they're gonna have a disposition on the charges. Then I'll have a parole hearing. But I still got a pending case.
You still have a pending case right now, Mr. Dwyer?
Yes.
Do you know when your next court date is?
I'm not 100% sure, but yeah, I'm not 100% sure.
When was the last time you were in court? Do you know?
I got my attorney got me on no, like I don't got court trained, like I don't go to court. She go to court for me. So whenever they find, like whenever they about to come up with a disposition for the case, I'll be getting calls so they could I guess go over things.
Okay. All right. So what I'm going to have to do then today, Mr. Dwyer, is put your case on hold and continue it until that case is disposed of, because you're not supposed to have a revocation hearing until you have no pending charges. Per state regulation, we're not allowed to hold this hearing until everything is disposed of at this point. In the meantime, have you reached out to any of the public defenders, or do you plan on hiring an attorney for this hearing?
I would like to reach out to maybe possibly a public
defender
and
yeah,
where things go, because I'm not sure if my attorney could do the parole revocation hearing. I'm not sure if that's what she do, but I can ask her.
Okay, so what I'm gonna do in the meantime, like I said, we can't hold this hearing until that any pending charges are disposed of. So we're gonna continue this until that happens. I'm gonna just let my supervisor know that you are gonna look for an attorney for this hearing, and we'll send an email down to the public defenders unit for the revocation process and let them know that you'll be seeking counsel for whenever it does take place, okay?
Got you.
All right, any questions for me right now, Mr. Dwyer? I don't want you to speak too much if you do still have something pending.
No, it's all right. Everything's all right.
Okay, all right, so hopefully I'll see you soon. Go ahead.
Just one question, like, since is this just like a mistake, like that they called me, or like y'all don't got it in the record that I got a pending case?
So we received something from your charging officer, so that's who you were reporting to in the community, that it was disposed of. It must have just been incorrect.
The child support is a pending case and stuff like that, or that's like, I'm talking like civil stuff, that's not pending?
Well, no, it's criminal charges. Do you have anything criminal pending right now?
No. I thought you was talking about like anything, like, you get what I'm saying?
Oh yeah, no. I mean, so what's been brought against you is criminal, is a violation for criminal charges.
Nah, I get it. I thought it was like you got to clear up all your court cases. If it's child support, you owe any child support or anything. Like, I thought it was like stuff like that.
No, so is that what's pending right now? Is your child
Yeah,
support case?
I think I got child support, stuff like that, and I'm not. Yeah, I think it's that, and I got a civil matter. Like I'm waiting on a lawsuit.
Oh, no, we don't
Okay.
have to wait for that. Okay, so then let's go back to the attorney part. Do you want to continue today and I can
Yeah,
reach out to the
I
public?
could. No, I continue. I'm all right without an
You're
attorney.
okay moving forward today without legal representation?
Yes.
Okay, all right, so, and then I'm just gonna cover my basis right now. So just to confirm, you have no criminal charges pending at this point? It's all civil? You have a civil case,
Yeah,
you said,
I got a civil case.
and
pending.
child support? Okay.
Yeah.
Okay, all right. And you're willing to move forward without an attorney. So your other right you have is the right to receive the written notice of charges of violation. Did you receive that written notice? You got it a long time ago when you were first brought in.
Yeah, probably. It's just so much stuff. So much stuff. Like, yeah, I really don't remember. You get what I'm saying? I just been in here so long without. I just don't.
Do
Yeah,
you believe you were able to review it back then? It is from 2024.
I believe so. I know I'm guilty of what I'm guilty of it.
All right, so then you also do have the right to review all the evidence submitted. You have the right to submit evidence in support of your own case. You also have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. So do you understand all of your rights, and are you still ready to move forward with today's hearing?
Yes, ma'am.
All right, so we're gonna now review the charges that the state, your parole officer, is bringing against you and the information underlying those charges. So for charge number 1, the condition of reporting, the charging officers stated that on 7/25/24, you were scheduled to report to the Hartford District Office for standard reporting. You failed to report or call your parole officer. On 7/26/24, the PO called your phone number that you provided, 860-984-0435, and the number was no longer in service. Based upon your behavior, you're in violation of release direction subsection reporting. Charge number 2, the condition of residence. The charging officer reported that on 7/26/24, this PO conducted a home visit at your approved residence. Your sponsor stated you no longer reside in the residence. You do not have permission to change your residence. Based on your behavior, you're in violation of release direction subsection residence. On charge number 3, the condition of absconder, the charging officer reported that on 7/25/24, you were scheduled to report to the Hartford District Office for standard reporting, and you failed to report or call your parole officer. On 7/26/24, your parole officer went to your approved residence. Your sponsor stated that you no longer reside at the residence and you did not have permission to change your residence. On 7/26/24, your parole officer attempted to call your phone and it was not in service. At this time, you have stopped reporting and communicating with parole officers altogether. Your whereabouts are unknown and you cannot be located. You have made efforts to conceal your location, and based on your behavior, you're in violation of release direction subsection absconder. And charge number 4, the condition of obedience to the law. The charging officer reported that on 11/11/24, you were arrested by Hartford Police, and the current charges are 53-202C, illegal possession of a weapon, 53-202W, large capacity magazine, 53A-167A, interfering with an officer resisting, 21A-279A1, possession of controlled substance, first offense, 29-38, illegal possession of a weapon in a motor vehicle. It's 53A-217, criminal possession of a pistol/revolver. 53A-212, stealing a firearm. 14-301, failure to obey stop sign. 14-299, traffic control signal. And 14-224B3, evading responsibility, injury/property damage. You were arraigned on 11/12/24 at GA14 Hartford Court under the companion dockets ending in 441S and 042S. Your next court date is 12/6/24, and based on your behavior, you're in violation of your parole condition of bail laws. Charge number 5, the condition of drugs. The charging officer reported that on 11/11/24, you were arrested by Hartford Police Department, and you had in your possession control at the time of your arrest 2 clear knotted bags containing white powder-like and rock-like substances, along with the black digital scale. And for charge number 6, the condition of weapons, the charging officer reported that on 11/11/24, you were arrested by Hartford Police Department, and you had in your possession control at the time a Glock 34 9mm pistol with a Glock switch, making the gun capable of fully automatic rate of gunfire, and 31 rounds of extended magazine loaded with 12 9mm live rounds and 1 additional live round in the chamber of the Glock. This Glock is reported to have been stolen. State did file the following exhibits that are being marked for identification purposes as Exhibit A, the signed statement of understanding and agreement of conditions of parole. Exhibit B, the remains to actual custody. Exhibit C, the parole violation report. Exhibit D, the parole violation notice. Exhibit E, the decision information summary. Exhibit F, the revocation summary. And Exhibit G, the Hartford Police Report number 240292222. And Exhibit H, the State of Connecticut Judicial Pending Case Detail for dockets ending in 441-S and 042-S. The state also did file addendums to the parole violation report. The first one was back in November 13, 2024, that states that on August 28th, 24, the Board of Parole issued a warrant based on the report declaring Dwyer an absconder from parole supervision. And then on 11/11/24, Dwyer was arrested by Hartford Police and charged with the illegal assault weapon, large capacity magazine, interfering with an officer resisting, possession of the controlled substance first offense, illegal possession of a weapon in a motor vehicle, criminal possession of a pistol, revolver, stealing a firearm, failure to obey stop sign, traffic control signals, and invading responsibility, injury / property damage. And on that same date, he was remanded into custody by Hartford Police and was served his parole violation notice, the parolee rights at Hartford Correctional Center on November 13th, 2024. The second addendum submitted by Parole and Community Services was submitted on July 15, 2026, and states that Mr. Dwyer appeared in court on July 9th, 2026, under dockets ending in 441-S, as well as 042-S. And it states that all of the charges against Mr. Dwyer were nullied for both dockets. And that as of July 15, 2026, per the clerk staff at GA 14, there are no other pending cases for Mr. Dwyer. So just to confirm one more time, Mr. Dwyer, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today, even though it's probably back in 2024?
Yes.
Okay. I have not received anything from you at this time. Do you need time to submit any evidence for your own behalf?
No, ma'am. We could proceed.
Okay. And there's no witnesses. So at this time, Mr. Dwyer, it is your opportunity to respond to the parole violation charges against you. However, please remember that you do have the right to remain silent if you choose to do so, because it is the state's burden to prove the case against you. However, you did already mention that you're guilty of the charges. So anything additional at this time towards the charges only?
I just was going just to clarify, just to let you know, like, I know you seen like the charges of my violation. My first, this is my second violation. My first violation, I don't know if you could go back to that, but I got a lot of write-ups, GPS violation, I probably got over like 50 of them.
Okay.
But when I got released the second time, I didn't have no write-ups. I have no write-ups. It was just, I was going through a mental health situation at the time, and I wasn't on proper medication. Nothing caused me to, I didn't get in trouble. I was, all my urines was clean. I didn't I was just going through something, a hard time, and I just stopped reporting. And it wasn't because, hey, they checked. I just stopped reporting altogether. I still had all my belongings at my sponsor house. I just stopped going not because I was in trouble or anything like that, just going through a hard time. That's the only thing I want to say.
No, I appreciate your statement. And after I announce my findings, if we move forward to the next part, we can talk more about what was going on and stuff like that, and what's going to happen once you're released, okay? So I am going to announce my findings at this time, Mr. Dwyer, okay?
Yes.
So on charge number 1, I am making a finding that you violated the condition of reporting based on your admission at today's hearing, as well as evidence presented in State's Exhibits A and C. The same for charge number 2, I'm finding you violated the condition of residence based on the evidence presented in State's Exhibits A and C. For charge number 3, I'm finding you violated the condition of absconder based on the admission at today's hearing, as well as Exhibits A and C. On charge number 4, I have separated it its obedience to the law is the condition into different parts. Each part is going to be identified as an offense as charged, and I'm making a partial finding. So for the charges of the 14-301 failure to obey a stop sign and 14-299 traffic control, I'm making a no finding for those as they're infractions. They're not considered crimes. However, I am going to make a finding on the remainder of the offense based on the evidence presented in State's Exhibits A, C, G, and H. Charge number 5, I'm finding you violated the condition of drugs based on the evidence presented in State's Exhibits A, C, and G. And charge number 6, I'm also finding you violated the condition of weapons based on the evidence presented in State's Exhibits A, C, and G. So that does conclude the fact-finding portion of this hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I'll recommend. So I did take note, Mr. Dwyer, that you were doing pretty well, it sounds like, until something just went wrong while you were out there. You mentioned your mental health wasn't doing well. So what are your plans upon release? What are you going to do different? Do you have plans for mental health treatment? Or do you plan to live? Stuff like that.
Not to cut you off.
Oh, you're good.
I want to, like, when they first started me, they had me with a mental health parole officer. And I was doing so good, they felt like I didn't need it. I didn't need to see them like every week. But once they stopped that, not right away, but it's just like, it was too soon for them to just release me. I mean, give me to the just the regular parole supervisor. I actually was like, I had to like building a rapport with my first parole officer. Things was great, and they just switched me, and it's just like, it was just me though. It was honestly me. I don't know, like I said, it's like everything was going good. I'm not no write-ups, no anything. I'm just doing and just something and it's just I don't know. And it's not the first time it ever happened like that. So I do want to I probably want to start off like once I do release, I do want to go to a sponsor, but I probably want to start off somewhere like in a controlled setting, probably a halfway house, to be honest with you.
Okay,
And
what location's best for you? What location? Hartford, New Haven, Norwich, Bridgeport, or Waterbury?
Waterbury.
Waterbury, okay. Tell me about like work. Do you have any thoughts about where you're gonna work or what your plans are for employment?
I'm not going to make up anything or nothing. I'm not sure, but I know when I was in Waterbury halfway house before, they helped me get a job. I actually was doing a good job out there. So I know it's possible if I put energy and whatever, if I really want it, I could get that done.
Mr. Dwyer, that's a plan though. You're gonna work with the resources available to you. That's what it sounds like that you're saying to me, correct?
Yes. That's why I actually, nobody probably ever say, I want to go to a halfway house. They want to just sponsor home. But that's why I said, I just want to start in the secure so I can just build my way. Absolutely.
So you'll utilize anything that they have available to you, work with your officer, try to just get back on your feet?
Absolutely.
Well, that sounds good to me. Anything else you would like the board to know before I announce my recommendation?
No, I respect any recommendation you make.
Well, I am going to announce it, okay? So I did review all of the evidence submitted and I listened to your testimony today. With that, Mr. Dwyer, I'm going to recommend that you serve an approximate 1 year and 9 month period of confinement as a sanction. That's with a re-parole date, I just want to of August 13th, 2026. I'm going to recommend the following conditions. I just want to cross my T's and dot my I's quickly. I want to make sure that I have the right date. Discharge. Good. Okay. Yeah, so that's going to be my date that I'm recommended. So August 13th, and I'm going to recommend the following conditions. Behavioral management program for anger management, no contact with victim ZC, a general no contact with KB, RR, MJ, and SB, mental health treatment, no operation of a motor vehicle without parole officer's permission, and halfway house placement. All right, so what happens next, Mr. Dwyer, is my recommendations going to the board actually on that date, August 13th. So at that day and that hearing, you will not be there. It's administrative, but the board can only do 2 things. They can adopt my recommendation and you'll walk out the door that day, And then if for any reason they would want to see a longer period of confinement as a sanction, they'll ask you to come back for another hearing to address their questions and concerns before anything longer is imposed. So this will be the last time I speak to you, hopefully. If the board adopts it, like I said, you'll leave on that date. You won't even have time to get notice from us because normally that comes within a week of the hearing date, since I'm recommending you be released the date of your board review. Does that make sense?
Makes sense.
You're good?
Yes, ma'am.
Any questions?
No, no questions.
All right, and if you don't walk out the door that day, don't totally panic. It just means we're gonna bring you back for the board members to speak to you, okay?
Okay.
All right, but, and like I said, if you do walk out, we just don't have time to let you know ahead of time. So McDougal will be processing you to get you released to that halfway house, okay? Since you're on special parole. All right?
All right. Thank you.
All right. No problem. Good luck to you, Mr. Dwyer. And ask for help next time if things feel off, okay? If you start
right,
feeling like it's not okay, advocate for yourself.
Got you. I appreciate you. Thank you.
No problem. Good luck to you. This concludes a revocation hearing for Deshaun Dwyer, inmate number 393038. Good luck to you, Mr. Dwyer.
All right, you have a good one.
You too. Hey, Kristen, I see Hartford is red, but not with us, correct? They're not logged in with us.
They're red, but you should be able to dial them.
Just try dialing, still okay. Oh, because we might be in the meeting. Got it. Good morning, Hartford. Oh,
Good morning.
thank you. We just have one with you today, Mr. Flores.
What's the first name?
Tootie? Teudi.
One moment, let me check to see.
Good morning, Officer McClay.
Good morning. How are you?
Good, how are you?
Good.
He's currently in RHU.
Okay, are you able to bring him down or is
Yeah,
that
it'll
not?
just take me a few minutes.
Yeah,
I
that'd
can,
be perfect.
Okay, cool.
Yeah, if you can get him down, thank you.
Okay, yeah. Hey, what's up, Randy? I need Flores to have a pro visit. He's got a video visit. Yeah, he's in 3, cell 3. Yeah. Yeah, the paperwork I have from July 31st. He probably got discharged over the weekend. Surprised Dr. Reyes ain't at the hospital. Oh, yeah. Okay, thank you. Hey, this is Flores with our pro visit. I need Flores in 22. Thank you. Okay, I found him. Just a few minutes.
Okay, great, thank you.
You're welcome.
That sounds good.
he coming? Is he coming from his? Yeah, okay.
Okay, I just want to go live on the record for the case concerning Victor Rivera, inmate number 285140, scheduled for 11:15 a.m. This case will not be moving forward today. His attorney has waived the hearing for today's proceedings. Thank you.
It'll be the last one on your right. There, he hooked up and up there. Right. Yep, you're on set.
Good morning, Mr. Flores. How are you?
Good morning. I'm all right. Feeling a little better.
Good morning. Morning, Officer McClay. We're gonna get started, okay, Mr. Flores?
Yes.
All right, so good morning. I'm Parole Officer Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Tudy Flores, inmate number 374085. Today is Monday, August 3rd, 2026, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Hartford, right? Yep, Hartford Correctional Center. Can you please state your full name and DOC inmate number for the record?
Tudy Flores, 374085.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is your charging officer. Can you please identify yourself for the record?
Yep, Parole Officer McClay out of Hartford Parole.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant a revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Flores and Officer McClay, can you both please raise your right hands? Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yes.
Thank you. So we're going to go over the procedure for today's hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state or parole officer is bringing against you. We'll then review and identify the exhibits that have been filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. After the state is finished, you will then have the same opportunity. At the conclusion of this hearing, I'll inform you my findings, which will be based upon the available evidence. Mr. Flores, do you have any questions about the purpose or procedure before we begin?
No.
Okay, so you have important rights, and we're going to review them now. You have the right to be represented by an attorney. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. So Mr. Flores, were you informed that an attorney could represent you at today's hearing?
Yes.
Okay, and do you plan to seek counsel for today's purposes?
No.
All right, one more time, just to confirm, you're willing to move forward today without legal representation?
Yes.
Okay. You also have the right to receive the written notice of charges of violation. Did you receive that written notice?
Yes.
And you were able to review that?
Yes.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay, we'll now review the charges that the state your parole officers bring against you and the information underlying each charge. So Officer McClay, can you please review the charges for us, starting with number 1, condition of drugs?
Charge 1, drugs. On 4/13/2026, you admitted to using cocaine. You signed a voluntary admission form. You are in violation of condition number 2, obey all laws. On 4/28/2026, you rendered a urine screen that was sent to Premier Biotech to test for cocaine substances. On 5/1/2026, Premier Biotech reported that you were positive for cocaine. You are in violation of condition number 2, obey all laws. On 5/5/2026, you admitted to using cocaine. You signed a voluntary admission form. You are in violation of condition number 2, obey all laws. On 7/9/2026, you rendered a urine screen that was sent to Premier Biotech to test for cocaine substances. On 7/15/2026, Premier Biotech reported that you were positive for cocaine. You are in violation of condition number 2, obey all laws. On 7/22/2026, you admitted to using cocaine and alcohol. You signed a voluntary admission form. You are in violation of condition number 2, obey all laws. Charge number 2, no consumption of alcoholic beverages. On 4/13/2026, you admitted to using alcohol. You signed a voluntary admission form. You're in violation of your additional condition alcoholic beverage consumption throughout your period on parole. You are prohibited from the consumption of alcoholic beverages. You will be required to submit random toxicology screening to monitor compliance. On 7/22/2026, you admitted to using alcohol. You signed a voluntary admission form. You are in violation of your additional condition, alcoholic beverage consumption throughout your period on parole. You are prohibited from the consumption of alcoholic beverages. You'll be required to submit random toxicology screening to monitor compliance. Evidence, Exhibit A, Connecticut Conditions of Special Parole and Reentry Fellow Agreement. Exhibit B, Connecticut Board of Parole Remand to Actual Custody Order. Exhibit C, Notice of Parole Violation, Notice of Parolee Rights. Exhibit D, Parole Violation Report. Exhibit E, Voluntary Admission Forms. Exhibit F, Premier Biotech Results. Exhibit G, Misconducts. Exhibit H, State of Connecticut Board of Pardons and Paroles Decision Information Summary. Exhibit I, Disciplinary Report from Hartford Correctional Center from 7/22/2026. And Exhibit J, Timeout Program Compliance Discharge Report, ineligible for top.
Thank you. Mr. Flores, one more time to confirm, you did receive the notice of parole violation, the parole violation report, and all the other documents identified for today?
Yes, I received it.
And you
Yep.
received, and you reviewed all the evidence submitted as well as the notice?
Yes,
You
I
reviewed
did.
everything you were given? Okay, perfect.
Yes.
We have not received anything from the defense at this time from you, Mr. Flores. Do you need time to submit any evidence or exhibits on your own behalf?
No, I don't, there's nothing to present. I was honest. I mean, I was dirty.
Okay,
She's
hold
been
on. We're
good
gonna
to
let
me.
Officer McClay speak first, and then you'll have an opportunity, okay?
Yep.
All right, so we don't have any witnesses at this time. So at this time, it's gonna be the state's opportunity to speak towards the charges, make a statement and testify with respect to probable cause and the severity of the allegation. So Officer McClay, anything at this point? Any additional?
Yeah, so I've been supervising Mr. Flores for over a year now. This is his first technical violation. He started relapsing around like April, alcohol and cocaine. We did put him through the graduated sanctions process. We did have him going to substance abuse treatment, moved him to IOP. He was very involved in CCAR, going to the CCAR groups. He had a CCAR recovery coach. Once he was in IOP, he did come to me and say, I do want to move forward with inpatient. So we put him in APT. And then within about a month or so, he relapsed again. He's always been very honest about his substance use. He's always taken accountability, which is why we thought the timeout program would be the most appropriate placement for him. And then unfortunately, within a couple hours of us dropping him off at Hartford Correctional, he did catch a DR. It was for intoxication. In the evidence, let's see, Exhibit I in the disciplinary report, it does state that he was observed in the dorm that he was in smoking marijuana. So it was a Class A intoxication ticket, which also was concerning because of his substance use. He was told multiple times before he went in, do not catch a DR because you will be ineligible for top. And he was told again when we were in the Sallyport, do not catch a ticket or you will be ineligible for the timeout program. So because of that, they did mark him ineligible. So we did have to make it a technical remand. So between that and between him coming out of APT and then within a month relapsing, I do think it is appropriate at this time to warrant incarceration just because of the substance use.
Thank you.
You're welcome.
And then, Mr. Flores, it is now your opportunity to respond to the parole violation charges against you and the testimony presented by Officer McClay. But I do want you to know that you also have the right to remain silent if you choose to do so. So at this time, would you like to make any statements towards your charges?
She's correct. I failed. That's
Very well, I appreciate your statement. I'm just gonna take a quick moment, then I'm gonna announce my findings, okay?
yeah.
So on charge number one, Mr. Flores, I am going to make a finding of probable cause for the condition of drugs based on the evidence presented at State's Exhibits A, D, E, F, G, as well as testimony presented by you at today's hearing. Same thing with charge number two. I am going to make a finding of probable cause for the condition of no consumption of alcoholic beverages. Again, based on testimony presented today at the hearing, as well as State's Exhibits A, D, E, and G. And I am also going to find, Mr. Flores, that the acts are serious enough to warrant revocation. And I've also determined that you should be detained while you await that revocation hearing. So what happens now is Officer McClay is aware of it. We're going to let the facility know about it. You will remain incarcerated until we have your revocation hearing, which will be scheduled within 60 business days of your remand to custody. At that revocation hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. And if so, if there is a finding, the hearing examiner will recommend whether or not your parole should be revoked and what, if any, sanctions should be imposed. So that does conclude today's hearing, Mr. Flores. Do you have any questions?
Yes, I just want to know, because I like to prepare myself, like mentally. After 15 years messing up like this, I just want to know what am I facing, like, so I could like tell my family, like I'm lost. That this is my first time, so I don't know. I just want to like more or less prepare myself. How much time I'm gonna be doing? I mean, I get a lot of feedback from these guys. They don't know what's going on. They might say predicament, but I just want to know.
The only thing I would recommend is that you
what
don't.
other options I have to help myself.
So, Mr.
That's
Flores,
all.
I'm going to recommend a few things. The first major one, I know that there's not much else to do in there. Do not listen to what is being said around you. You're very different. You are you, and everybody has their own stories and journeys. I would not recommend that. The other thing I can recommend is, has the public defender's office reached out to you for an attorney? Would you like for me to let them know you're going to move on to a revocation hearing and that you would like an attorney, because they can actually guide you better through the process?
I mean, if it's going to help me, I just want to know, like, so I'm here now. I mean, I messed up. I messed up. I just want to know, like, do I have any more options for myself to help myself? Like,
Get
I don't
out of
know.
the orange jumpsuit. That can help yourself. Don't catch any more DRs.
No, I'm in a cell now. I'm not in a dorm setting no more where you can wear your tans. I'm in a cell. So cells is, I guess they gotta separate with, so we wear jumps. Up there, we wear jumpers.
Okay, so just make sure you don't get in any more trouble, and we'll see you probably in the next, I would say, few weeks, probably within a month. At that hearing, I can't tell you what you're looking at because I have to do a more in-depth review of your case. There's some information of Officer McClay's recommendation in the paperwork you received. You can read through that again. And if you are looking for an attorney who can guide you, they can't tell you what's going to happen. Nobody knows what's going to happen, but maybe they can just,
I got a letter from an attorney, but I don't.
Send it back. It can't hurt, and you can say no thank you after you speak with them, but they work on these cases every day, and they have a better understanding of what's expected at the hearings. They can explain it in more detail to you that I can't explain and Officer McClay can't explain,
Right.
okay?
Can I ask my parole officer something? Like, from experience on McClay, like people like me that violate under these circumstances, what would I be looking at? Like,
I mean, Flores, every case is different. I don't want to put anything on record at this time because, again, every case is different. So, we're going to wait. Everybody kind of has to do their part.
Right.
And then, once we do revocation, that's when we'll have the recommendation, okay? Because I don't want to tell you something and that changes and it's wrong because that wouldn't be fair on my part, okay? But I think this is a good time to sit down and really think about your sobriety and, how you want to go about this when you come back out on supervision in the community.
Definitely.
Okay, it's important.
Definitely, yep. Thank you.
Mr. Flores, so we will notify you of when that hearing's scheduled, and if you do still have the paper for the attorney in the public defender's office, send it back. Just have a conversation with them. You can move forward with them, without them, whatever you choose, but they can, again, give you better information than we're allowed technically to give you, okay?
Yep.
All right, so this does conclude the preliminary hearing for T.V. Flores, MA number 374-085. Okay, we'll see you in a few weeks, okay, Mr.
All
Flores?
right, that takes like 60 days before I go to an actual hearing.
We have 60 business days to schedule it. We try to do it in about 4 weeks or so, 4 or 5 weeks, but you'll be given, we'll send you a letter once it's scheduled, okay?
All right, no
All
problem.
right,
Thank
we'll
you.
see you soon. Good luck to you. Thank you, Officer
All right.
McClay.
Have a
All
good
right,
day.
talk to you
All
soon,
right.
Flores. Thank
All
you.
right, thank you.
Yeah.
Sergeant Lee?
Yep, you're all set.
Okay.
Thanks.
Officer Trusello, you're muted.
Now I have to do it all again. Sorry. Thank you. So good morning. I just want to put on the record that the hearing scheduled at 11:30 for English Watson, inmate number 234416, was waived by his attorney and will no longer be moving forward today. That is all. Thank you.